Let me give you a short breakdown of how the constitution was bent and later partially redeemed. India's emergency 50 years ago wasn't declared in a war room. It was whispered into a place behind closed doors in Lutyens, Delhi. Not by tanks rolling in, but by signatures rolling out, and upheld by a judiciary too timid to speak. Let's start with Rajnarayan versus Indira Gandhi, a case of 1975, where Justice Jagmohan Lal Sinha of the Allahabad High Court found Indira Gandhi guilty of electoral corruption. Verdict: her 1971 Lok Sabha win was held void. For 6 years, she couldn't hold public office. 13 days later, what does Indira Gandhi do? She advises the president to declare emergency under Article 352, citing internal disturbance. That phrase, vague, undefined, became the legal entry point to tyranny. Within hours, Article 19, Article 21 frozen. Over 1 lakh people detained under Maintenance of Internal Security Act. Many without charges, without trial. And when lawyers turned to the courts with habeas corpus petitions, came the most shameful judgment in Indian history. ADM Jabalpur versus Shivkant Shukla in 1976, also called the habeas corpus case. A 5-judge Supreme Court bench ruled, even if someone is illegally detained, they have no remedy during emergency. Only one judge dissented, Justice H.R. Khanna, saying that even without Article 21, the right to life is inalienable. His reward: he was superseded for the post of Chief Justice of India, a first and only in Indian history. Here are some truths rarely spoken about. Law Ministry bypassed. The draft emergency proclamation was typed by a junior officer in Indira Gandhi's residence, not in the Ministry of Law of Justice or Home Affairs. It was pushed to the president for signature without cabinet approval. Second, judges transferred as punishment. High Court judges who gave verdicts against the government were punished with transfers, including V.D. Tulsapurkar and Justice M.C. Chagla and others who resisted executive overreach. Presidential ordinances skyrocketed. More and more ordinances were passed than regular bills, bypassing parliament altogether. This wasn't just authoritarianism, it was legal manipulation. Of course, lawyers protested, but they were jailed. Over 300 lawyers across Delhi, Allahabad, and Bombay were detained. Bar associations went silent. Only a few, like Shanti Bhushan, Fali Nariman, resisted openly. Indira Gandhi lifted the emergency in January 1977, confident of a comeback. But the people answered with votes. The Janata Party swept the elections. In 1978, Parliament passed the 44th Amendment. Now, Article 21 can never be suspended, even during emergency. Grounds for emergency were also revised. Internal disturbance was replaced by armed rebellion. The emergency wasn't just a political event, it was a legal coup, silent, systematic, and signed into law. The lesson: the Constitution is only as strong as those who defend it, and as weak as those who forget it.